Hello, everyone. My name is Ariella Wagner. I'm the founder of SunRay Construction Solutions, a national construction document service. Today, we have another fabulous webinar conducted by the none, the only best construction lawyer in Florida, Alex Barthet. And today's fabulous topic is shit. I forgot to send my notice to owner. What now and how do I get paid? So without further ado, I introduce Alex Barthet.
Thanks, Ariella. This is Alex Barthet. I am a board-certified construction lawyer here in Miami, Florida. We handle cases throughout the state of Florida. And today we're going to talk about what you can do to recover if you make the mistake of forgetting to send your notice to owner. So let's go through the agenda quickly, and then we'll get right into the topics. So first, we're going to talk about the basic rules for notices and liens and bond claims. Then I'll talk about why maybe you didn't actually miss a deadline, even though you think you did, which is another way to say we'll go through some of the major exceptions that we see clients not understand that don't actually cause you to lose your lien rights, even though maybe you thought you did. We'll talk about other bonds on a bonded job that you may be able to go after, bonds that you didn't even know existed. I'll then talk about how to file a lawsuit for breach of contract and for unjust enrichment. And those are the two claims that you can sometimes bring with your lien or bond claim. But if you've lost your lien or bond rights, these are the types of claims that you're going to have to bring as a last resort. And as always, we will answer any questions you have at the very end. To ask any questions, use the GoToWebinar chat box on the right. You can submit your questions at any time, and we will answer them all at the end. Just make sure not to include any names of people or companies in your questions. So let's get started. So let's go over the basic lien, notice, lien, and bond rules. So we have a framework within which we are all understanding of what we have to do in order to secure our lien rights. So as you all should know, you need to send a notice to owner, which is a statutory document. It's not something you can make up yourself and put notice to owner on top. I had a client ask me that yesterday, that he sent his own notice to owner because it was a notice that he prepared and he sent it to the owner. And I said, no, unfortunately, that's not the way it works here in Florida. So you need to use the proper form, and when you use SunRay, they have all the forms in their system up to date with respect to all the latest Florida statutes. That notice needs to be received by the owner no later than 45 days from your first work on the job or delivery of materials to the job site. Now, as I said that, I know that Ariella's hair got even curlier because she wants to tell you that it's 40 days, not 45 days. And the reason she says 40 days is because there is a rule that allows SunRay to get your notice, prepare it, put all the postage on it, and then they bring it to the post office and have their manifest stamped, which is a list of all of the items they brought to the post office with all the certified mail numbers. The postal worker reviews each one and then stamps that manifest to prove that it was brought to the post office by the 40th day, 40th day. And when that happens and that manifest is prepared and stamped by the post office, it doesn't even matter if the notice actually arrives to the owner. Maybe it gets lost in the mail. Maybe it gets returned because someone knocked over their mailbox. None of those things matter as long as it's delivered to the post office and the manifest is stamped by the 40th day. What's important to know is you need to do it early. The 45th day or 40th day is the outside deadline. You should be noticing your jobs as early as possible from the time you have the contract or the first delivery of materials or work on the site. So you can notice the job on day 37. If I sign a contract today and I may not start work for 3 months, I could still send a notice today or tomorrow once I have my contract in place. So remember that as well. The next rule is that the claim of lien or the notice of non-payment or claim on the bond, if the job is bonded, must be received no later than 90 days from your last work or delivery of materials to the job site. That 90 days is, and the 45 days, by the way, is counted from the day after the delivery of materials. You count every day, including weekends and holidays. And if the 45th day or the 90th day lands on a weekend or legal holiday, then you roll it to the next business day where the court or the post office is open. That's how you count the 45 days and the 90 days. Again, even with the 90 days, you don't have to wait until the 90th day. You can record a lien while you're still doing work on the job 1 week after you've last delivered materials. So keep that in mind. Don't wait till the last minute to do either of those things. The next thing is you need to file a lawsuit to enforce your claim of lien within 1 year of the recording date of the claim of lien. And for claims on the bond, lawsuits on the bond, that needs to be 1 year from your last work on the job. So there could be a delta of as much as 90 days between filing a lawsuit on a lien versus filing a lawsuit on a bond. So don't mix up those two rules. What's important is you shouldn't be waiting that long anyways. I recommend that if you haven't been able to get paid within 60 days of recording your lien or sending your bond claim, then you need to consider hiring a lawyer to pursue the claim. It's not going to get better just by waiting. Now, there are lots of exceptions to these rules, and this is where we get into understanding some of the ways that maybe you think you lost your lien rights, but in fact you didn't. So again, maybe you think you lost them, your lien rights, but maybe you didn't. So let's talk about some reasons why you didn't need to send a notice to owner. So the first and most common is that you don't need to send a notice to owner when you have a direct contract with the owner. I think you should. I strongly recommend that even if you have a contract with the owner, you notice the owner, especially with respect to residential jobs. They get this document in the mail. It's somewhat intimidating. That's a good thing. It will cause, or I should say, it may cause the owner to be more concerned about not paying you. You don't need a notice to owner when you have a direct, and again, it's technically a notice to contractor on a bonded job, when you have a direct contract with the bonded contractor. So for example, if the job is bonded, let's say it's a public job, and that job has a bonded contractor, and you are the plumber on the job, then you don't need to send what's called a notice to contractor to the contractor, which is equivalent to the notice to owner when you have lien rights, because you have a direct contract with a bonded contractor. So I had a client come in to me some months ago, and he said, oh, I actually don't have any claim because I was supposed to send a notice to owner and I never did. And I said, well, isn't this job bonded? And he said, yes. I said, well, didn't you have a contract with the general contractor who issued the bond? He said, yes. I said, well, then you never needed to send that notice. So be aware, if you have a direct contract with a bonded contractor, you don't need to send that notice. But again, I still think you should. With respect to these first notices, the notices that go out within the 45 days, I strongly recommend that you set up a process in your office where you say any amount over a certain level that we're going to sell or contract for, we notice those jobs. We don't try to figure out, well, we need a notice here, we don't need one there. You just say anything over $500, anything over $2,500, anything over $10,000, whatever you want in your office, and you just say that when we have a job that's going to exceed that amount, we're going to notice it right away. And then you don't have to worry about whether you sent a notice or you didn't send a notice. Now, on the back side, which is when you need to record a lien or make a bond claim, this is the 90-day notice. You don't have to do that when you have a direct contract with the bonded contractor on a public job. So let's take my example again, right? The school board of the county that you're in hires a contractor. That contractor issues a bond. That a contractor hires you because you're the plumber, the electrician, or the roofer, you can then, you don't need that first notice because you have a direct contract with a bonded contractor. And on public projects, as a sub to a bonded contractor, you don't even need the second notice, the notice of non-payment. But again, I still recommend that you send one. So keep that in mind. That's another big exception that most people don't know about. On a bonded job, the 45 days on the notice to owner, again, technically the notice to contractor, doesn't even start to run until you have actual or constructive knowledge of the bond. So let me give you an example. We represented a subcontractor on a project, on a public project. So there was the public owner, the contractor, the subcontractor, and then our client. So our client was a subcontractor on a public job. They forgot to send the notice to owner. Now, clearly they needed to. Again, technically the notice to contractor because the job is bonded on a public job. But it turns out when he came to us that the contractor did not record a copy of the bond for the project. Now, he had already been off the job for 60 days. He started a year ago and had been off for 60 days. So clearly it's too late to send this 45-day notice. But again, there's an exception in the lien law that says if the bonded contractor on a public job does not record a copy of that bond, putting everyone on notice of that bond, then the time to send that 45-day notice doesn't even start to run. So we found that the job was bonded. So we then prepared a notice to owner. Again, technically on a bonded job, it's called a notice to contractor. We sent it. The next day we sent our notice of non-payment, and the day after that we filed our lawsuit. Our client was owed about $100,000. And it took about 3 months of litigation, but we were able to convince the court and the other side that they failed to record this bond, and all of our notices were technically timely, and our client was paid all of his money, interest, and legal fees. When the client came to us, he was expecting I was going to give him bad news, and it turned out that he got all his money. This is a perfect example of the philosophies that you should employ when you are undertaking your collection, which is never say die. You know, there may be an exception in the lien law that you don't know about that can give you rights. So keep that in mind. Another thing to look out for is, does the project have another bond for you to go after? So if the job is bonded, the general contractor will issue a bond, and that bond is recorded in the public record. Sometimes on jobs that are bonded and sometimes on jobs that are not bonded, that general contractor or the owner may require the subcontractors to issue payment and performance bonds. So let me give you an example. You have an owner, it could be private or public, hires a general contractor, and that general contractor may not be obligated to issue a bond. Maybe he is, maybe he isn't. In our example right now, let's assume that he doesn't issue a payment bond on that job. But he or she has doubts or has concerns about the sub, or the owner has required that major subs on the job, the roofer, the electrician, plumber, glazing contractor, that all of those subs get bonds. And then you may be a supplier or a subcontractor to that subcontractor. If that sub issued a payment and performance bond, that sub that hired you, you have a claim against that payment bond if you are not paid. So the first thing you need to do is figure out, is the sub that hired you bonded? So this bond is not recorded in the public record. So it's sometimes hard to get your hands on it. I would tell you that where I see most sub bonds exist are on projects of larger value, where the subcontract's contract is usually in excess of $500,000. And usually it's for a sub that is of significant scope in the job. So again, foundation, roofing, glazing, mechanical, electrical, plumbing, structural, and their scopes of work are sizable, several $100,000 into the millions of dollars. So how do you get your hands on it? You should ask the contractor for a copy of that sub bond. You can also ask the subcontractor for a copy of that bond, but be careful, they may not give it to you. But there is a way to get it, and you can send a formal written demand to both the contractor and the subcontractor for a copy. You can get a copy of that request, that formal request, at thelienzone.com/forms. But also know that when you use SunRay and SunRay prepares your notice to owner, and that notice to owner goes to the contractor and the subcontractor, there's a little line in that notice to owner that says, if this job has a bond, please send us a copy. And if they don't send you a copy, there are penalties for their failure to do that. But if you wanted to send an additional notice, you can do that. And you can get that form at thelienzone.com/forms. So let's run through some other causes of action. Again, your best way to get paid on a construction project is to timely and properly perfect your rights on a lien or a bond claim. So that should be your primary concern all the time. But in addition to that, or in lieu of those rights, let's talk about suing for breach of contract. So you may have an agreement, in writing or not, with another party, and that agreement is the basis of what you're going to sue them for. It can be a proposal, it can be a quote, it can be an invoice. Maybe it's a more thorough 2, 3, 5, 80-page contract, and that's going to be the basis of your lawsuit. Keep in mind, though, if you sign a contract with a contractor or subcontractor, and it says with the proper language, it has to be written correctly, and you should get legal advice if this is a significant issue for you. It has to have, if it has pay when paid language, then you may not have a cause of action against the person that you signed the contract for if they have not been paid for their work. So there are ways under the law that if the owner doesn't pay the contractor and the contractor therefore doesn't pay you, and your contract with the contractor has a pay when paid provision that's written according to Florida law, you don't have a legal cause of action to sue them for breach of contract. Now, if you stay to the end, we're going to talk about pay when paid provisions, because I'm going to tell you what our next webinar is in a month, and we're going to spend the entire 20 minutes talking about pay when paid provisions. So the other claim that you can bring if you forgot to send your notice and don't have lien rights or bond rights is unjust enrichment. The claim for unjust enrichment is a equitable theory, and the basis of it is, I am suing you because you received the benefit, that's the enrichment, and you haven't paid anyone for it, that's the unjust part. So because you were unjustly enriched, you should have to pay me for the work or materials that I provided to the project. This is typically brought against a party that's further up the chain, like the owner. So for example, if I am a subcontractor, maybe I'm the glazing contractor, and I know that the contractor was not paid by the owner, I can sue the owner for unjust enrichment because they never paid the contractor for my work. Therefore, instead of paying the contractor for my work, they should just pay me. Unfortunately, though, if the owner has paid the contractor and the money never got to you, or the owner says, and this is what we typically see, well, I've paid the contractor all the money he or she is entitled to, because after I take back all of the deducts and I had to hire someone else to finish the job, I don't owe that contractor anything. If the owner claims that they do not owe anybody any money, and they can prove it, by the way, they may claim it. The question is, can they prove it in court? But assuming that they can, then you don't have a claim for unjust enrichment, because the theory is they have not been enriched. They may not have paid you, or they may not have paid the contractor, but they were not unjustly enriched. It's a relatively weak argument, unjust enrichment. It's kind of a Hail Mary. But again, you're owed money and it's the only claim you have, it may be worth making because maybe you can use that legal pressure to try to settle the case. Do know that claims for unjust enrichment do not entitle you to legal fees, meaning even if you win the claim for unjust enrichment, you will not recover your legal fees in the process of suing someone for unjust enrichment. So let's recap briefly of what we discussed. Know the basic notice and lien rules. Send your notice to owner early and send it all the time. Set up a process in your office so that everything gets noticed all the time. Do not wait till the last minute for your notices or your liens or your bond claims. Make sure, if you have any doubt, that you check the lists of all of the available exceptions. And we talked about a lot of them here, but there are still others, to make sure that before you give up on a claim for lien or bond rights, that you have verified that there's not some exception where you in fact still have those rights. Try to find out if the subcontractor is bonded. Again, the reason this is important is some of the time frames associated with a contractor's bond don't apply to a subcontractor's bond, meaning you may have missed a deadline for the contractor's bond, but if the sub is bonded, you may still have rights on that sub bond. So finding that sub bond may be absolutely critical. And then understand the rights that you may have under breach of contract and unjust enrichment. So Ariella, with that, do we have any questions? And as you look for those, if you are looking for more information about Florida's lien law, collections, bonds, contracts, you can go to our weekly podcast called the Lien Zone Podcast, and you can get it on iTunes, Google Play, or Stitcher. We have these monthly webinars. You can go to sunraynotice.com/education and see the entire list for the year of all of the webinars and live seminars that we will be conducting. The next event we have, as I told you before, is Pay When Paid Sucks. So do this to get paid anyways. It's on May 21st from 9 to 9:20, and we will run through the Pay When Paid provisions. What does it look like, how to deal with it, how to remove it from your contract, and some other things you should consider either when you are dealing with a Pay When Paid because someone is forcing a Pay When Paid on you, or if you want to make Pay When Paid provisions part of your contract, what's the best way to do that? So Ariella, any questions?
So far, Alex, there aren't any questions. We do not have any questions. But if anyone has a question that they could think of later, or they're nervous to even ask a question in the little box, do not worry. You could send us an email and we will respond to you immediately. Alex, thank you so much for conducting yet another amazing webinar. I wish everyone a great day. Stay safe.